Hello, everyone. Thanks so much for joining us tonight. We're really excited about this. We have been using the CORA process and open meeting sunshine laws in Jeffco to help us uncover some things that have been occurring in Jeffco that have been helpful to us as parents. And so Jeff is with the Colorado Freedom of Information Coalition, and we're really happy that you're here to help us with information or understand about your organization. And I want to just mention, I know that you're a nonpartisan organization and you really, yes, and you just exist to help people of all perspectives with transparency in the government. Would that be a fair statement?
It absolutely is.
And what we've discovered is that transparency really equates to trust, no matter what your perspective is, and it can really be a benefit to our communities. So we've had questions that you've responded to us immediately and really helped us. So you have been a major benefit to our community in Jeffco. And if there are others from other districts as well, welcome and thanks for joining us. So I'll go ahead and just have you go right into it, Jeff. And I know you're going to cover the CORA process, open meeting sunshine laws, and a little bit on criminal justice. Or not. Yeah. Okay, perfect.
I'll touch on that.
Yeah, that's perfect.
I'll touch on that.
Great.
Okay.
And
hi, everybody. Welcome to my basement, where I've been working out of for the last couple of years. A lot of the time, I have an office to go into, which I do a little bit, but this is where I've been working. I'm Jeff Roberts. I'm the executive director of the Colorado Freedom of Information Coalition. The COFOIC is as Lindsay said, is a nonpartisan 501c3 nonprofit. We've been around since 1987. For a lot of that time, it was an all-volunteer organization. For the last 9 years, about 9 years since I was hired, we've been very active, and our goal, our main mission is to educate the general public in Colorado and the journalist community in Colorado about their rights under the open government laws. And so we're talking about state and local government, not so much the federal government. And these are the laws. There's 2 public records laws in Colorado, the open meetings law. There are rules governing your access to court records, the administrative records of the courts, and we deal with all of that type of thing on a daily basis. We also advocate for more government transparency. So, you might see us testifying on a bill in the legislature or helping behind the scenes to craft legislation or sometimes oppose it. So that's our main mission. I want to take a second and show you our website. So I'm going to share my screen and go to our website, which is coloradofoic.org. And I'm going to put this in the chat, but there's a lot on this. So I'm a former Denver Post reporter and editor. Being a journalist was most of my career until this job. When I had before that a little bit, I worked in public policy. But I consider open government my beat. So if you go to the blog, there's 530 articles on there about open government issues in Colorado. The main thing I want to show you is something we have put online for the first time ever, starting last November, which is our Sunshine Laws Guide. And so this used to be in booklet form. We used to publish it that way. And now it is online, it's free, it's indexed by topic. Everything I'm going to talk about today is in this Sunshine Laws Guide and a lot more as well. And because it's online, when they change the law or there's some important court decision, I can update it and it'll be there as a resource for anybody. I'm going to stop this and I'm going to put in the chat just real quickly the link to that guide so that you have it handy. Really encourage you to take a look at that and explore the rest of the website as well while you're on there. We're also very active on social media. We consider that a way to keep conversations going about these issues. I know some of you are active on Twitter. There's our Twitter handle, our Twitter page, and I'll put Facebook on there too, just if you want to do that as well. And there's that. So I have some slides, which I'm going to go to. Once again, sharing my screen. And let's see, here it is. Okay, can you all see that? I'm going to take that as a yes. Lindsay, can you see that?
Got it.
Okay, great. Okay. And I am going to start from the beginning here. So I want to start with just a few examples. Like I said, I was a reporter, an editor, journalist, and I come at public records from the point of view of a journalist. It helps a journalist do their job, right, to inform the public. And so journalists are using these laws all the time. And so the examples I'm going to use are from news organizations, and they're pretty recent. This is a Colorado Sun story from December, I think, and the Sun obtained email records, very commonly requested public record these days, that showed early dysfunction in the state's COVID-19 testing program in schools. Troubles with the vendor that included staffing issues, showing up late, technology not working, using inappropriate language in schools. So, the reporters are trying to figure out what's going on with such important situations like that, which I imagine is something that you all care quite a bit about. And when officials, don't necessarily talk about all aspects of it, public records can reveal things that they don't necessarily want to always talk about. Here is another COVID-related story that the Denver Gazette did. The governor had gotten this cell phone tracking software this was early on in the pandemic, to track whether Coloradans were social distancing enough. Very early in the pandemic, when this was kind of the big thing, the big response. This service was offered to the state for free. That's how it was touted. But it turns out, a reporter gets records, and the state ended up really covering this company's expenses. So once again, you can tell, dig into it and tell more of a story. Staffing shortages, everybody's experiencing that. Aurora Sentinel used public records to show how much more the public was paying for staffing shortages, or to pay Aurora police to cover staffing shortages. You can use it to tell all kinds of stories. Another story, really important series that the Sun is doing about fentanyl overdoses. And, they've been paying money, we'll talk about that later, for autopsy records and other records to show the extent of the fentanyl overdose problem. And I think Boulder County was most of their focus. The Post, the Denver Post, where I used to work, you remember the awful thing that happened in Old Town Arvada, where there was a fatal shooting, and the Post used all sorts of records, all sorts of documents to essentially do what we call a TikTok, where they really tell the story almost moment to moment, and the documents really help them do that. 9 News, this is a fairly recent story. They wanted to get a sense of what people who work in the city of Denver were saying they wanted exemptions from getting the vaccine. What were they, what were their reasons? And the city ended up giving 9 News one record with the person's name redacted, and then wouldn't give them the rest of them. And then they wanted this particular record back, but 9 News reported at least on the one record. They thought it was important to show, what people were claiming as exemptions, at least in the public sector. And sometimes it's a story about what records you can't get. So this is a problem that we've identified in the past. We had a DU law student work on this issue of email records retention. So we had written a letter to the governor very early on in the pandemic, asking for a lot of things about pandemic related records. But one of the things we requested, and we had a bunch of organizations sign this letter, was that they retain records, emails and other records, so that this story could be told, not only in real time, but you could go back and look at how government responded. And the Post looked into this and found repeatedly that records, emails that they were requesting were told no longer existed. That's an ongoing issue. So I just wanted to start with some examples to show you how reporters use these laws. Obviously, they're not just for journalists, they're for everybody. And you all are finding that out, that the open government laws could be very helpful for whatever you're interested in. So what are the legal grounds for access to your government? On the federal level, there's the Freedom of Information Act. In Colorado, we have the Colorado Open Records Act, which was passed by the legislature in 1968. And we have a separate law called the Criminal Justice Records Act, which governs only law enforcement records, so police, sheriff records, that type of thing. And the presumption of access to these records is quite different. The CORA, the Colorado Open Records Act, covers all records of state and local government except for law enforcement records. I'll touch on law enforcement stuff. I know that's not your primary interest, but I just want you to know that it exists. And then, of course, there's the open meetings law. It was initiated by the voters of Colorado in 1972. It originally just covered state government and the legislature, but of course, since then, it's been expanded to local government as well. And before this, it was pretty haphazard. And what this does is it standardizes your right of access to government. I think you might know why all this is important, but there was a Colorado Supreme Court ruling in 1983 that summed it up really well. And I'm quoting from it on this slide, that, for a free self-governing people, you need information about your government to shape how you want to vote in elections and to hold government accountable. And public records laws are for everyone, not just journalists, not just activists, not just companies. They're really for anybody, anyone. Both public records laws say any person is entitled to inspect public records, even canines, I guess. So CORA, as I said, CORA covers all records of state and local government. And there's a pretty broad presumption of access. So essentially what that means is that you should presume that the records you're interested are open for inspection. And unless there is something either in CORA or elsewhere in state law or some court decision that says you can't have them, or the government has discretion to withhold them for one reason or another. And I'll get into that a little bit later too. But the main thing to remember here is that you should ask. You should ask for the record and then have the agency, the government entity, whatever, tell you why you can't have them for some reason, or they have to be redacted. So, a portion of them can't be released, that type of thing. What's a public record? It really can be anything that's made, maintained, or kept by the government entity for the exercise of government functions, and especially involving expenditure of public funds, but it really could be anything. So what does that mean? It could be, it used to be in a piece of paper, but these days it typically means something digital. So that could be a PDF, it could be a database, a spreadsheet, it could be an image, it could be a video. And it really is anything that they maintain for the exercise of governmental functions. Response time. So unlike the federal FOIA, we have a pretty good time of response in CORA, in the Colorado Open Records Act. And you hear, at least I hear sometimes, of people waiting months or years to get federal government records from the federal government sometimes. In Colorado, for records that are not readily available, the presumed time of response is 3 working days or less. And if extenuating circumstances exist, and those are enumerated in the statute, they can extend that by another 7 working days. The issue that you might run into is that, yes, this is in the law, this is in the statute, but it's fudged quite often. So you may ask for records, and it's been 3 working days and you're wondering, where are my records? And they'll, a government entity might say, hey, we just have so many requests, it's really hard to respond to everybody. This has been, especially during the pandemic, a very common excuse. And you as the requester are not likely to sue over this issue. You politely remind them of your request, you remind them of what the law says, but sometimes you have to wait longer than what it says in the law. So why even use CORA? I should back up on that and explain that you can just ask a government entity for public records. You can ask if you know something, there's some report you're interested in, and the clerk or something, the city clerk, you could say, hey, can you send me a copy of that if it's not on their website? You don't have to use the CORA, or although a lot of governments want you to make a CORA request so they can keep track of that stuff. But the main reason to use CORA is, number one, it starts a clock, so that what you see on the screen, they're really supposed to respond to you within a certain period of time. And then another main reason is they have to respond to you. So if you just ask a question, hey, I'd like to have that, you may or may not get an answer. But if you file a CORA request, they have to respond to you. In Colorado, like in a lot of states, there is a cost. There can be a cost for obtaining public records. Some states, Ohio, for instance, have never charged for what's called research and retrieval. They're one of the few states that don't, but in Colorado, it hasn't been specific in the law all that long, but it's been specific in court decisions that governments can charge to find the records, pull the records, and review and redact the records. So that's what's called research and retrieval. The law caps the hourly rate at which they can charge you after the first hour. The first hour must be free, and if you've got a request that takes less than an hour, you want this report, whatever, a lot of things should take much less than an hour. But you may have already seen this, where you make a CORA request, especially for something like emails, and you get, they'll say, hey, that's going to be, so many dollars. It could be hundreds, sometimes thousands of dollars. And so then you have to work, think about how you want to perhaps rephrase your request so it's not as expensive. This is one of the main problems that I think we have with public records in Colorado. We had another DU law student last year do a research report on the cost of CORA. And, we had several examples in there. And the issue that we'd like to see addressed is, yes, there's this cap on the hourly rate, which is adjusted for inflation every 5 years. And that's going to come up again in 2024. And who knows what it'll be with the way inflation is going. But there's no cap on the number of hours. And there's nothing that requires the records custodian, the person who in the government who keeps the records, to explain to you what they did to research, compile the records. So we'd like to see something that at least requires an itemized receipt for the requester, and maybe some other reforms that could make it less expensive sometimes, because public records become not public when they get too expensive, and it's a roadblock sometimes. So this is an example from Colorado politics where they wanted records. They got records about the state emergency operations during the early part of the pandemic, to see how the government was responding to it. They had to pay more than $1,200 for these records. The news organizations can't afford to do that for every records request, but some they decide to do it because it's important enough to tell that story. This is a blog post I did a few years ago. I had someone from the town of Sheridan who was asking for records from the city clerk for just a few months of the city clerk's emails. He had very specific search terms, and he was told, well, that'll be $20,000. And so he called me, just not knowing what to do about that. And it turned out that I interviewed someone in the town. They just were not set up to retain their emails, to search their emails, that type of thing. Somebody had to recreate the database a day at a time to find records for his request. So I just ended up writing about it and how ridiculous it was that this guy just wanted emails for a few months from the city clerk, and it was pretty much impossible to get those. Way off limits. So if you get a really high bill or estimate, and I always suggest that you ask for an estimate, you have some things you can do. Emails, for instance, you want to set some parameters, how you might want to talk or email with the records custodian. Is there a way to narrow your request, either by listing parameters such as date, sender, receiver, search terms, that type of thing. In some cases, an elected official might make a request for you. You actually have, because there's so many of you in your group, you may have the ability to crowdfund the cost of an expensive request. If it's something you're all interested in, think about sharing the cost of a request that gets really expensive. Maybe it won't seem so expensive and you'll still get the records. And then ask for that itemized invoice to make sure that you're getting a good idea of why it costs so much. Sometimes it's not really the time it takes to pull the records from, say, an email box, but they're charging you for the time to review the records to make sure that they don't release something that either shouldn't be released or they think they have discretion not to release. Sometimes they have an attorney review it before it goes out. The city of Denver has that policy. Lindsay, I thought maybe we should have decided this at the beginning, but I thought maybe I'll go through these things, and because there's several of you on the call, we'll just wait to do questions at the end, if that makes sense.
Yeah, that's perfect.
Okay,
Or do
good.
you want people to put them in the chat as they think of them?
Yeah, that's
Okay.
a good idea.
Okay.
But I'll just go through this stuff and then we can get back to questions.
Perfect.
So, I said that, presume that the records that you want or that you're interested in are open for inspection, because that's what CORA says, unless there's something in the law, elsewhere in statute, in some court decision that says either they cannot release these records or they have discretion not to release the records. And so there's a section in CORA of records they can't release. Records about your kids. You can get those records, but I can't get those records, about your students, your library card, your utility bill, that type of thing. One thing that can be frustrating sometimes for reporters in particular, records of sexual harassment complaints or investigations. If you remember a few years ago, this was a problem at the state capitol, and it was frustrating that the law says this. You can't get these records. So reporters had to think of other ways to tell that story. There's some other things in here, like personnel files, but you have to know something about how the courts have defined that. So when I talk about personnel files, I'm talking about the personnel files of public employees. And you're thinking, they're public servants, right? I should be able to get records about, their job performance. And that's true, you should. So CORA will say in there that you can't have personnel file information. But what the courts mean by that, have said that what that means is that it's really a public employee's, what they call personal demographic information, their home address, their telephone number, their personal financial information. It's not, the reason they resigned or were placed on leave or that type of thing. This is one that we have to fight a lot, because a lot of governments see that in the law. Oh, I can't give out personnel files, and they just deny that. So sometimes we have to push back on that, and more often than not, we can get the requester or help get the requester those records that they're interested in, if they happen to be personnel related records. Here's an example of that. In Uray County, during, I think it was about a year ago, no, I guess, yeah, it's about a year ago, the newspaper there got a tip that some county employees had been disciplined for working too much during the pandemic. So they wanted to get these records, and the county denied them. The county actually took the reporter to court, and they ended up settling after a lawyer intervened, because those records are public. And I think the employees themselves ended up releasing the records to the newspaper because they wanted that story told about how they were disciplined, not for doing a bad job, but for working too much, to doing their jobs during the pandemic. This is another one that we were able to help on, and I wrote about it on my blog. Last May, a reporter who works for a TV station in Colorado Springs heard that a school bus driver had been disciplined for slapping a student, a 10-year-old girl on his bus, because she wasn't wearing her mask properly. And this is a TV reporter, so she wanted the school bus surveillance video to really tell that story. The story would have a whole lot more impact. The school district denied her request, saying that both the federal education privacy law applied and that personnel records exception that I was talking about. Well, there's ways around FERPA, that federal education privacy law. If you don't identify the child's face, and the personnel records exception doesn't apply to somebody's job performance. And actually, there was a district court decision in Arapahoe or Jeffco a few years ago specifically about discipline records of school bus drivers. So we were able to get this video with the child's face blurred, so it didn't identify the child, but it showed this horrific thing that this bus driver did, and that bus driver was disciplined or left. I think left the district. So mandatory denials, some of which have to be, you have to know a little bit more of what it just sort of says on its face in CORA. Sometimes the case law is really helpful. We have all that stuff in our online guide that I mentioned. It links to not only the statute, but if there's a pertinent ruling from the Court of Appeals or the Colorado Supreme Court, it links to that as well in the guide. So it's good to kind of know how the courts have treated these laws. So there's the mandatory denials, and then there's a section in CORA of records that a government entity can withhold upon a finding that it would be contrary to the public interest to release them. So ongoing civil or administrative investigations involving an employee, that type of thing. Emails that people provide to government entities. One that I heard about today, details of security procedures. Today, I heard from a journalist down in Alamosa. There was an executive session because of the county commission for this purpose, details of security procedures. But it actually involves some budget requests from the DA. So reporters trying to get into that. So it's both a CORA thing and an open meetings law thing. Some of these things, so the details of security procedures was put into CORA after 9/11. But sometimes, governments use these exceptions in very odd ways. So here's an example of that. A few years ago, a reporter for the Daily Camera in Boulder was just doing a story about Ralphie the Buffalo, CU's mascot. And she asked for records about where Ralphie is kept when Ralphie's not used in CU football games. And CU actually cited this security provision that was put into CORA after 9/11 to withhold records about Ralphie's whereabouts, which is silly. She didn't really fight it because it was actually funnier, made for a sort of a funny story to just even, put that out there. It wasn't that big of a deal to know for sure. It was more of a story that they withheld it using this post 9/11 security provision. Another excuse you may have already seen, if you do enough CORA requests of government, you're bound to run into this exception in the law, which is called deliberative process. And so this is what it says in the law is if material is so candid and personal that public disclosure would stifle frank and honest discussion within the government. So you'll see this sometimes when you request communications within the government. And if they don't want to release something, this can be a catch-all. So if you get this denial, deliberative process, the entity, the government entity, is supposed to provide you with a sworn affidavit of why they think these releasing these records would cause substantial injury to the public interest. And then if you want to, and it's, it's kind of a big deal, but you could ask the records custodian to actually go to court to prove that, to show that releasing the records would cause substantial injury to the public interest. I wouldn't do that probably without having a lawyer represent you, but it's a way to try to fight it, at least. This was a story that I did on my blog about a successful challenge to a deliberative process denial in the city of Denver. So, you actually had a judge look at this and say that, no, they shouldn't have withheld these records. Here you go. But I gotta also say that this is a very hard one to fight. And that's probably why the records custodians use it quite a bit. Oops. Trying to move this thing here. There we go. Emails. Emails, and you may have requested emails already, but this is probably, it's probably now the most commonly requested public record. Emails, if people in government won't talk to you about what's going on, maybe their emails will lend some insight to what's been happening behind the scenes or how a decision has been made. And so the main thing to know, or a main thing to know when you're requesting emails, is that it really, it's the content of the emails that really determines whether it's a public record or not. And so if the email or the text message was sent or received using a private account, it still can be a public record if it pertained to public business. If they're sent and received on private accounts, you may have to do a CORA request for, directly to that public official for that, and mention that you're interested in any communications on their private email account or their phone, if you have reason to believe that that's how they're conducting business. There's really only one high court decision in Colorado that's really important about emails. This happened a while ago. Some of you may remember Tracy Baker was the county clerk of Arapahoe County, was having an affair with somebody in his office. The Denver Post and the Rocky Mountain News were very interested in communications between the two of them. And this went all the way up to the Colorado Supreme Court, which ruled that anything involving their affair was not a public record. But if those communications also mentioned the county budget, the Post and the Rocky could have those. And actually they had to be redacted to provide that. So, just know that it has to pertain to public business, the business of the government. When you're requesting an elected official's email, some of it may be private if a constituent has asked for confidentiality. That's in the law. If they say, please don't share this one with anybody. This is to an elected official. This happens with state legislators and may happen with county commissioners. I just want to tell you something about something that's going on. Then they can withhold that email. Records retention is an issue. I think I might have mentioned this already with emails. Sometimes you can request a public official's emails only to find that they've been deleted, destroyed. And the state law on this is not very good. When you run into this issue, request a copy of the government's records retention policy. And a lot of these are on the website of the state archivist. You can see them. Most governments will adopt the policies that are promulgated by the state archivist. And so you'll see in there that email itself is not listed as something that necessarily needs to be kept for a particular period of time. It's the subject matter of the email that determines how long they have to keep it. I know I'm throwing a lot of stuff at you, but once again, this stuff is all in our guide. Settlement agreements are another thing commonly requested public record. Government can't contract its way out of the open records law. They can't say in a settlement agreement with an employee who is fired or whatever, they can't say this is all secret. It's got to be released. It involves money, that type of thing. Some of you may want public records. You may want to do some analysis on public records. So when I was at the Denver Post, I was a data journalist for some of that time, quite a bit of that time. So a lot of my job was to analyze public records databases. So it was very important to me to be able to get public records in spreadsheets or databases, that type of thing. And that was something I specialized in. But until 2017, you weren't necessarily entitled to public records, CORA records in digital formats. So we now have a section of CORA that says if the records are searchable, so a searchable PDF, for instance, versus a static PDF, that you can't do anything with, you can't search it. If they're kept that way, if they're kept in a searchable format, you're entitled to them in that format. If they're kept in a sortable format, like a spreadsheet, you're entitled to them in a sortable format. So, and this is minus any confidential fields. So they have to excise the confidential fields and give you the rest. So you are entitled to that. Our organization actually worked to get this passed, and it's something that we're proud of. This came into play at its most basic level just last fall. A woman who keeps a close eye on a public charter school in El Paso County. She, knowing about this provision in the law, she specifically requested records from this charter school in digital format, and she ended up with this box, this cardboard box full of paper that had been left out in the rain. And the school's attorney said, sorry about that. Well, we actually got a lawyer involved in this, and pointed out this law, and she got her digital records pretty quickly. So this was kind of it's not really what we were thinking about when we helped get this law passed. I was thinking about databases and spreadsheets, not really rain soaked paper in a cardboard box, but it helped this particular person. So you make your request, and you can be denied. And like I said, there's various reasons, some very legitimate, that public records can be withheld. But if you think that they were wrongly withheld, and you've talked about it with, say, me, what are your remedies in Colorado? Some states have an administrative appeal process. We don't have that in Colorado. Your remedy really is to go to court. But if you prevail in court, you can get your court costs and your legal fees, your attorney fees provided to you. That's actually mandatory that they have to be awarded to you if you prevail. There is a time period for filing a notice of intent to sue. It's 14 days. So if you're thinking seriously, I just know I'm right on this and I want to challenge it. You have to let them know. And within that 14 days, the government entity, the records custodian, is required to have a conversation with you at the very least to try to work it out. And maybe you end up doing more than that. You go to mediation or something like that. I don't think that happens a whole lot in Colorado, but hopefully you can work it out without having to actually sue. So writing the CORA letter, we have on our website in a few places, we have a template that you can use. You will find, and maybe you found this already, that government entities want you to use their form to submit a CORA. And they can do that, but sometimes there's not enough room on that form. If there's not enough room, I recommend also emailing a letter, making sure the records custodian got your letter. But the elements of what you should include in that CORA letter, some things that are pretty important. First, you want to, if you know what you want, just ask for what you want. Be as detailed as you can. It's going to limit your cost. It helps them find what you're actually looking for. If you can be specific, be as specific as you can. You want to ask for records, not information. You're not asking them questions. They're not required to answer your questions. They are required to provide any public records that exist that you asked for. So you're asking for records that show or something like that. You're not just saying, please tell me, X. You're asking for records. Always ask for an estimate of the cost. If it's going to exceed what you think is a reasonable amount to pay, 25 or 50 bucks or whatever, you really want to know that ahead of time. You want to know if there's some issue that is going to make this very expensive. And then really important to include at the get-go is asking for a written explanation of the grounds for any denial. And that includes any redactions that might be made, which include a citation of the statute that authorizes the withholding of the records. So you ask for that up front. You are entitled to this. There's a portion of CORA that entitles you to that explanation. So just ask for it right away. Ask for it up front so they include that. And then if you get some denial that you're puzzled about or whatever, you could email me and ask me about it, that type of thing. So I am not going to spend really much time at all on criminal justice records because I don't think that's your primary focus. But I just want you to know that there's this separate provision in the law that covers records of police and sheriffs, the Colorado Bureau of Investigation, that type of thing. Very different presumption of access for most records. In CORA, you presume that they're open unless there's something that says you can't have them. Criminal Justice Records Act, almost all records can be withheld if an agency thinks it would be contrary to the public interest to provide them. That's usually when some criminal investigation is ongoing, that type of thing. Reporters are very keen on using this act, this law. We've had some good things happen to open up some records in the last few years with police body cam footage, police internal affairs records. You have more of a right to those than you used to. But overall, if you get in this situation, you want to know more about it. There's lots about it in the guide. You can always ask me about it as well. Let's see where we are. Oh, we're already almost at 9 o'clock. There's so much to cover. I'm going to go through the Sunshine Law, the Open Meetings Law fairly quickly. The main thing it says right at the beginning of this law is that it's the public policy of Colorado that public business may not, public policy is public business may not be conducted in secret. So the idea is that your state government, your local public bodies, their proceedings should be in the open unless there's something that allows them, something in the law that allows them to close the door. So what's an open meeting? So it's really any gathering convened to discuss public business. It could be in person. These days, it's often how we're talking right now on Zoom or WebEx, something like that. But it could also be an email or a text message, a conversation. Those meetings are meetings that the public can't really attend. For a local public body, which you probably deal with most of the time, a meeting under the law is a quorum or 3 or more members, whichever is fewer. State public body, it's actually a quorum or 2 or more members. Really just about any governmental body, including an advisory body to that government, is covered by the open meetings law. So the main thing to remember about the meeting is it has to pertain, to be covered by the open meetings law, it has to pertain to that public body's policy-making function. So, a county commission gets briefed by the sheriff on a crime that's happened, but the county commission doesn't have any policy-making function regarding that crime. That's technically something that they don't have to open up as a meeting. But just about everything else they do is related to their policy-making function, and they should open it up. Emails and text messages, I believe this probably gets abused quite a bit, and we never hear about it. If there's 3 or more, members of that public body, that local public body, it's a meeting. But if they're texting about some area of public business, or they're emailing about it, 3 or more members, that could be a violation of the open meetings law. This is an example from the Loveland City Council where they were caught doing that. There are certain things that they can do. There was a clarification in the open meetings law last year in legislation that allows elected officials to schedule meetings. I'm available next Tuesday. Forward information to themselves. Respond to inquiries from people who are not members of the public body. Pose questions related to discussion. We really should address this particular issue when we meet, for our meeting. So there's a few things that are non-substantive that they can do by email. This was implied in the law before 2021. Now it's explicit in the law. Public meetings must be noticed, full and timely notice to the public with specific agenda information where possible. That's not terribly strong. Gives, basically what that means is if they know something is going to be coming up at the meeting, if they know 24 hours ahead of time, they ought to include it in that agenda and that notice so the public knows what's going to be discussed at that meeting. Sometimes during a meeting, they might find the need to have an executive session during that meeting, and they didn't have it on the agenda. If it's reasonable that it's something that came up, and they didn't really think that they would need to, then that's probably okay. Minutes are supposed to be taken at meetings where something could be adopted, some position is taken, formal action occurs or could occur. There's no really, there's nothing that says how thorough minutes have to be. And sometimes that can be kind of frustrating for people who want those minutes. something you probably care quite a bit about are executive sessions. So there are certain topics that are authorized for executive sessions. Those are in the open meetings law. You can see them in our guide. But before they can go into an executive session, before they can close the door and keep you out of the room or turn off the Zoom so you're not seeing what they're talking about or hearing what they're talking about, they're supposed to announce to the public, to you, the particular matter they're going to be discussing in as much detail as possible without ruining the point of having a closed door meeting. They're supposed to cite the statute, cite the portion of the open meetings law that authorizes the closure, and then they take a vote. This gets abused. So announcing the particular matter to be discussed, there was a Court of Appeals ruling last year involving the Basalt Town Council, where they just said, we're going into executive session to get legal advice. And the Court of Appeals said, that's not enough information for the public. You have to be a little bit more specific about what you're talking about, what you're going to be talking about behind closed doors. This is an example from 2020 where the Glenwood Springs City Council ended up releasing the recording of an executive session, not because a court made them do it, but because there was a lot of pressure from the public who had a really pretty good idea that they went into this executive session, didn't properly announce it, and they really went off topic. They heard that they went off topic. So they released this executive session recording, which typically you can't get. And at the next meeting, people listened to it. This one guy said, got up to the microphone and said, I listened to this thing and you all acted and sounded like a bunch of clowns. Another thing to know about executive session is a public body cannot make a decision during an executive session. They can't adopt a policy, take formal action, or even do any informal decision making. So it's hard to prove this sometimes, but sometimes you see a public body come out of an executive session and immediately vote on something that they never discussed in public. So you're wondering, how did they come to that decision? And so, if you believe that they abused this authority, you can, once again, go to court and ask a judge to listen to the recording. Those recordings have to be kept except for attorney-client communications. And so that, they say, we went to an executive session to get legal advice from our attorney, and they're in there for 2 hours, and you're wondering if they were really getting legal advice. It's very hard to prove that they weren't doing that because there's no recording that's required. Common violations of the Sunshine Law: making decisions in executive session, discussing public business, in emails, text messages, amongst a quorum, 3 or more members of a local public body. Once again, that's a meeting that you're not invited to. So even if you can CORA for the records after the fact, you're supposed to be able to attend that meeting in real time. So there's other things that can violate the open meetings law. There's not a ton of teeth in the law. Once again, you can take them to court. A judge could release an executive session recording, release a portion of an executive session recording, and issue an injunction. Basically say, don't do this again, that type of thing. And then once again, you could get attorney fees if you successfully bring a complaint. So that is my presentation, and I guess it took about an hour, and I'm going to stop sharing and we can go to some questions. I also want to mention that we run a hotline, And so you're welcome to ask me questions anytime. I'll put my email address in here. And I'm also going to put the link to that Sunshine Laws guide in here again, in case some people join late, because that really has just about everything I talked about, actually has everything and more that I talked about. So let's see. Do you run into discrepancies with the redaction? I need some water. We've sent the same request to recipients in emails in 2 different agencies, found very different redaction practices. How would you hold them accountable? This is from Lindsay. Yeah, I mean, they're really supposed to, go by what is in the law. It really depends also on what provision they're using to redact the records. So, like I said, there are certain things that they cannot release, and then certain things that they have discretion to not release if they find that it would be contrary to the public interest. So, and then it can come down to how well they know the law. The laws get misinterpreted sometimes. So if you have a reason to believe that this was an improper redaction, let me know, and we can talk about it. We can talk about how you might respond. Are government employees associated with a CORA request usually alerted about the request? Are they given the name of the requester? That's possible. It's really, there's nothing in the CORA that says one way or the other. So if you're making requests about, for a particular public employee's communications, then that person's likely going to be alerted by that because they're going to need to search their email box. And they might be asked to search their private email box as well. Because like I said, their communications, if they're on private accounts, but they pertain to public business, then those are potentially subject to CORA as well. So that is very likely that they'll let that person know. If the records custodian is clearly biased, has a vested interest in said records not hitting public record because it has to do with them, can you request that someone else be responsible for pulling the records? You can request that. There's nothing in the law that says that that they have to turn it over to someone else. So there usually is a designated person as a records custodian. And if you feel like records are being withheld, then you can challenge that. If you're going to challenge that, you need to have some evidence, and that's the hard part, to find that evidence. So emails, for instance, where there are multiple people on the email, and can you show that an email was sent to a particular person or somebody was involved in it, but they're not producing that email. If they're not producing it, and it actually exists, they have to explain why they're not producing it. So it's a very difficult thing to show, but that's the challenge. Let's see. Are public meetings required to allow for public comment? Can private citizens make public comment, be required to give their personal information? So the open meetings law is silent on public comment. I hear about this a lot. It is really the the public body's own policy that determines what, how they do public comment. The main thing is they can't really discriminate based on somebody's viewpoint during public comment. So they can't shut somebody down because they're saying one thing about an issue and allow somebody else to talk. I have a pretty good article about this. If anybody is interested in it, I could find for you that sort of explains sort of generally what's allowed, what's not allowed as far as letting people speak during public comment. You may also run into public hearings on certain issues, and that's a separate thing. And that's also typically the government's, if an ordinance is coming up, for instance, they have a process for, making sure that there's a public hearing on the ordinance, that type of thing. That's a different thing than just sort of the open mic period at a board meeting where they let people come in and, and talk about whatever's on their mind. That's not in the open meetings law. Let's see. It seems like our county has had many executive sessions about the same topics. What actions are there to find out about what is going on? Once again, pretty tricky. It's because those recordings of the executive session are not public records, and the only way they're released is either the public body votes to release them or a judge makes them release them. Now, there's one other little thing, and you didn't ask about school boards, but there is a separate statute for school board meetings that's in addition to the CORA. And there was an amendment to that a few years ago, specifically addressing executive sessions for school boards. And what that requires is if they have an executive session, they're supposed to release their minutes within a particular period of time, shorter than any other. I mean, there's really no other deadline for releasing minutes other than in this statute. And those minutes are supposed to at least say they talked about this topic for this long, they talked about this topic for this long in executive session, to give you some idea what a school board talked about. That doesn't affect any other kind of public body. So, how do you find out what's really happening in an executive session? Sometimes somebody who's in that meeting, says something, will tell you something. That happens on occasion. If they come out of the meeting and they immediately vote for something that really didn't get much of a public discussion, you may have a suspicion that they made a decision in executive session. You can challenge that, ask a judge to listen to the recording. It's hard. It's hard, like that situation in Glenwood Springs that I talked about. People were listening in as that was being announced, including, I think, it might have been the DA who listened and was very suspicious that the council was first of all didn't announce their meeting properly, and was going to be talking about something that they weren't really allowed to talk about in an executive session, which ended up being sort of just COVID generally. And there's, they could, you could talk about certain things in the executive session, but you can't just ramble on about whatever. And so there was enough pressure put on this council. We have pretty good reason to believe you guys went way off topic in that meeting. And the council said, okay, and they just released it. And that's where the guy said, you sounded like a bunch of clowns. So you got to have kind of good reason to think that they're talking about things that they're not supposed to be talking about behind closed doors. Seems like our county has had many executive, oh, that you just did that one. Um, Okay. Is that it? Is that all is that the questions? Anybody have any others?
Well, I know we've had some aha moments here behind, as you've been speaking. We've got some work to do in Jefferson County. So this has been really informative, and there are many people who are hoping for a recording. So we will pass this on, and it's fantastic to know that we can reach out to you at any time as well. So thank you so much.
Yeah, please, please go to that guide, because it really, that's why we put it up there.
Yeah. Thank you so much for your time. Really appreciate it. Yes.
Okay. You're welcome, everybody.
All right. Take care.